$47,000. That is what the IRS collected from one family's home sale because nobody had updated a single piece of paperwork after the husband died. The house was worth $380,000. They had owned it for 31 years. The widow assumed the tax situation was the same as when they had bought it together. It was not. The rules had changed the moment she became the sole owner. Nobody told her. The IRS was not going to. Your home is probably the largest single asset you own. It is also one of the most publicly documented. Anyone can look up what you paid for it, when you bought it, and whether there is a mortgage on it. What most people over 60 do not know is that the home they spent decades paying off sits in a legal and tax situation that 5 specific documents can protect. And most American families have sorted none of them. I am not talking about your will. Most people have a will. A will is not enough. There are 5 documents that close 5 different gaps. None of them will be explained to you by the IRS, your bank, or your financial institution. The system runs on what you ask for, not on what you are owed. I spent close to 3 decades inside the federal tax system. Compliance work, notices, estate filings, cases where families lost money they should never have lost. Not because they were careless, but because nobody sat down and explained 5 basic documents while there was still time to sort them. After I left federal service, I started volunteering at tax assistance sites like VITA and TCE. I sat across from widows, widowers, adult children, managing a parent's estate, retirees who had done everything right for 40 years, and then discovered one missing form had quietly undone part of it. I am not on the payroll anymore, which means I can finally say some things plainly. These 5 documents are not complicated. They are not expensive relative to what they protect. And in most cases, the families who needed them most simply never knew to ask. Point 1. The Beneficiary Designation Form. The document that overrides your will. Most people believe their will controls what happens to their assets after they die. For your home, your furniture, your personal belongings, the will does govern those. But for your IRA, your 401k, your 403b, your life insurance policy, and any account with a beneficiary designation line, the will is irrelevant. And here's the bit nobody explains. The beneficiary designation form on file with your financial institution is a legal contract. It overrides your will entirely. The financial institution is legally obligated to pay whoever is named on that form, regardless of what your will says, regardless of what you intended, regardless of how much time has passed since you filled it out. This is not a gray area. In 2001, the U.S. Supreme Court ruled in Egelhoff that a former spouse was entitled to a deceased person's life insurance proceeds because the beneficiary form was never updated after the divorce, even though state law would have revoked it. The form won. Every time. Americans hold more than $9 trillion in employer-sponsored retirement plans and IRAs. For most families over 60, those accounts represent the largest financial asset they own, larger than the house in many cases. A single form, last updated 20 years ago, can redirect all of it. The Secure Act of 2019 made this worse. Non-spouse beneficiaries, your adult children, for example, must now withdraw all inherited IRA funds within 10 years. That compresses taxable income into a shorter window and can push your children into higher tax brackets for the entire decade. The wrong beneficiary designation does not just send money to the wrong person. It can also create an unnecessary tax bill for the right person. Carol is 67. Her husband passed away 2 years ago. She finds the IRA statements and notices the primary beneficiary listed is her mother-in-law, who died in 2009. There is no contingent beneficiary. The account defaults to the estate. It goes through probate. The distribution rules change. Her children face accelerated withdrawals and a larger tax hit than they would have if a simple form had been updated after her mother-in-law died. Carol says, "I didn't know I was supposed to check that. Nobody told me." Don't be Carol's family. What to do this week? Contact every financial institution where you hold a retirement account, life insurance policy, or annuity. Ask this: can you confirm the primary and contingent beneficiary designations currently on file for my account? Write down what they tell you. Check every name. Confirm they are still living. Confirm they are still the people you intend. Then update the form. In writing, submitted to the institution with confirmation that the change was received and recorded. Do this on every account separately. A change on one account does not carry to another. State note: 401k plans governed by federal ERISA law generally require written spousal consent before you can name anyone other than your current spouse as primary beneficiary. IRA accounts do not have that federal requirement, though some custodians impose their own. If you are married and want to name children or a trust as primary beneficiary on a 401k, your spouse must sign off in writing. Point 2. The durable financial power of attorney, the document that keeps the IRS out of court. Most married couples assume that if one spouse becomes incapacitated, a stroke, a fall, a dementia diagnosis, the other spouse can automatically manage their finances. Pay the bills, file the tax return, handle the IRA, respond to the IRS notice sitting on the kitchen table. They cannot, not automatically, not legally. And here's the bit nobody explains. A durable financial power of attorney is the document that gives another person, your spouse, an adult child, a trusted individual, the legal authority to act on your behalf in financial and tax matters while you are still alive but unable to act yourself. The word durable is the critical piece. A regular power of attorney becomes void the moment you become incapacitated. A durable power of attorney survives incapacity. That is the entire point of it. Without one, your family has one option: ask a court to appoint a guardian or conservator. That process is public. It is expensive. It takes months. And during those months, nothing can happen with your accounts, your tax filings, your IRA, or your home, because no one has legal authority to act. The IRS published guidance on this directly in 2025. For a durable power of attorney to work in federal tax matters, it must include specific information required under the Internal Revenue Code: the type of tax involved, the form number, the tax years covered. A generic durable POA may not be sufficient for IRS purposes without those specific provisions. This is exactly the kind of detail that gets missed when people use generic forms without legal review. Dennis is 71. His wife had a stroke in February. She had managed their household finances for decades. 3 accounts were in her name only. Dennis did not know who their tax preparer was, where last year's return was filed, or what IRS correspondence was outstanding. He had no legal authority to access her accounts. He could not respond to the IRS notice that arrived in March. He could not file for their joint extension. He says, "We had wills. I thought that was enough." A will takes effect at death. A durable power of attorney takes effect during incapacity, which is exactly when you need it. Don't be Dennis. What to do this week? If you do not have a current durable financial power of attorney, contact an estate planning attorney. If you have one that was drafted more than 5 years ago, have it reviewed. particularly to confirm it includes explicit authority over digital assets and meets current IRS requirements for federal tax matters. The document must be created while you are legally competent. Once capacity is in question, the process becomes much harder. State note: power of attorney requirements vary significantly by state, witnessing requirements, notarization, specific statutory language. A document that is valid in one state may not be automatically honored in another. If you own property in more than one state, discuss this with your attorney. Point 3. The home sale basis records, the documents that prevent a preventable tax bill. When you sell your home, the IRS allows you to exclude up to $250,000 of capital gain from federal tax, $500,000 for married couples filing jointly. That exclusion is one of the largest tax breaks in the federal code. Most homeowners over 60 know it exists. What most do not know is that the exclusion only applies to your gain, and your gain is calculated from your adjusted basis, not from what you remember paying for the house. And here's the bit nobody explains. Your adjusted basis starts with your original purchase price. Then it adjusts upward for every qualifying capital improvement you have made: the new roof, the kitchen renovation, the bathroom addition, the HVAC replacement. Every dollar of documented improvement reduces your taxable gain dollar $4. If you bought your home in 1988 for $140,000 and sell it today for $720,000, your gross gain is $580,000. As a single filer, you exclude $250,000. The remaining $330,000 is taxable at capital gains rates. But if you can document $180,000 in capital improvements over 36 years, a new roof, 2 kitchen renovations, an addition, a driveway, your adjusted basis becomes $320,000. Your gain drops to $400,000. After the exclusion, only $150,000 is taxable. The difference between a documented basis and an undocumented one can be $30,000 to $50,000 in additional federal tax. The problem: the receipts for the roof you replaced in 2003 are gone. The contractor for the kitchen addition in 2011 no longer exists. The permits are on file with the county, but not in your filing cabinet. The IRS does not ask for documentation at filing, but if they question your gain calculation, the burden of proof is yours. There is also a widowhood trap almost nobody warns about. When a spouse dies and leaves the home to the surviving spouse, the deceased spouse's half of the home receives a stepped-up basis to its fair market value at the date of death. In community property states, Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, Wisconsin, the entire home receives a stepped-up basis, not just half. In common law states, most of the rest, only the deceased spouse's half steps up. What to do this week? Pull together every receipt, permit, invoice, and photograph you have for capital improvements to your home, going back as far as you can find them. Create a simple spreadsheet: date, description, amount. Keep it with your tax records. If your spouse has recently passed, ask a CPA or a state attorney to calculate your current adjusted basis before you make any decisions about selling the home. Go to irs.gov and search Publication 5.03 for the official rules on home sale exclusions and basis calculation. State note: community property states, Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin have different stepped-up basis rules than common law states. If you're widowed and live in one of these states, your tax calculation may be significantly different. Verify with a tax professional. Point 4. The beneficiary deed, the document that passes your home directly to your family. When you pass away, your home does not automatically go to your children. If the only document governing it is your will, your home must go through probate, the court-supervised process that validates the will, pays outstanding debts, and eventually transfers title to your heirs. Probate is public. It is slow. It is expensive. In some states, it takes 12 to 24 months. Attorney fees and court costs come out of the estate. And while the process runs, your heirs cannot sell the property, cannot rent it out, and cannot make meaningful decisions about it. And here's the bit nobody explains. Most states now offer a transfer on death deed, sometimes called a beneficiary deed, a TOD deed, or a deed upon death, depending on the state. This document lets you name a beneficiary who automatically receives the property at your death, without probate, without a court order, and without delay. The key features: you retain complete ownership and control during your lifetime. You can sell the home, refinance it, rent it, or change your mind and update the deed at any time. The beneficiary has no rights to the property while you're alive. They cannot interfere with a sale, they cannot be affected by your decisions, and creditors cannot come after the property through them while you live. When you pass away, the property transfers automatically by recording the deed and a death certificate. There is also a tax advantage. Property transferred through a TOD deed receives a stepped-up basis to fair market value at the date of pass away, the same treatment as property that passes through probate or a trust. If your child inherits your home and sells it shortly after you pass away, they generally owe little or no capital gains tax on the appreciation that occurred during your lifetime. TOD deeds are not available in every state, though most states now offer them. Maryland's law took effect in 2026. Delaware's in December 2025. South Dakota recently added them. If your state does not yet offer a TOD deed, a revocable living trust accomplishes similar goals through a different mechanism. Thomas is 69. He owns his home outright in a state that offers TOD deeds. He has a will leaving everything to his 2 adult children. He assumes the will is sufficient. When he passes away, the home goes through probate. The process takes 14 months. Attorney fees and court costs total approximately $11,000 paid from the estate. His children cannot sell the home during this period. They are paying property taxes and insurance on a house they do not yet legally own. He says, from the moment he realizes his mistake while reviewing his neighbor's situation, "I didn't know there was another way." There was. It cost less than an hour with an attorney. Don't be Thomas's family. What to do this week? Search your state's name plus revocable transfer deed or beneficiary deed to confirm whether your state offers this option. If it does, contact an estate planning attorney to have one drafted. If your state does not offer one, ask about a revocable living trust as an alternative to probate. State note: TOD deed requirements, availability, and specific rules vary by state. Some states have very specific language and witness requirements. A deed that is not properly executed may be invalid. Work with an attorney who practices in the state where the property is located. Point 5. The property tax exemption application, the document most eligible homeowners never file. This last one is different from the others. It does not protect against financial crime, incapacity, or probate. It protects against something smaller but immediate, an overpayment you are making every single year without knowing it. Most states offer property tax exemptions for homeowners over a certain age, typically 65. Some are income-based. Some reduce the taxable value of the home. Some freeze the assessed value so it cannot increase. Some provide a flat dollar reduction on the annual bill. In many states, the benefit is significant. Hundreds of dollars per year, sometimes more. And here's the bit nobody explains. These exemptions are almost never applied automatically. When you turn 65, your county assessor's office does not review your account and apply the senior exemption to your bill. When your spouse dies and you shift from married to single, the office does not reassess your situation. The exemption exists. The application exists. The reduction is available. But you have to ask. Beyond the senior exemption, most states also offer a homestead exemption, a reduction in taxable value for your primary residence. Again, available, not automatic. If you moved into a new home and never filed the homestead application, you may have been paying taxes on the full assessed value for years when a significant reduction was available the entire time. There is also a circuit breaker program in many states, an income-based property tax relief program specifically designed for lower-income seniors. If your income dropped significantly in retirement and your property taxes have not, this program may reduce or eliminate your property tax bill. Most eligible homeowners have never heard of it. Beverly is 68. She has lived in her home for 22 years. She turned 65 3 years ago. Her state offers a senior property tax freeze that would have locked her assessed value at its 2023 level. Her home's assessed value has increased $47,000 since then. At her local tax rate, that increase costs her approximately $940 more per year. She has paid that extra $940 for 3 years, $2,120 total, because she did not know the freeze program existed and the county was not going to tell her. She says, "I just assumed the bill was correct. It was mathematically correct. It was not the lowest amount she legally owed." Don't be Beverly. What to do this week? Go to your county assessor's website or call your county assessor's office. Ask 3 specific questions. Do I have a homestead exemption on file for my primary residence? Are there senior property tax exemptions or freezes for which I may qualify? Is there a circuit breaker or income-based property tax relief program in this county or state? Write down what they tell you. Ask for the application forms. The application for most exemptions takes less than 30 minutes, and the savings can continue for years. State note: property tax exemption programs, eligibility ages, income limits, and application deadlines vary entirely by state and often by county. There is no federal standard. Your county assessor's office is the authoritative source for your specific situation. 5 documents, 5 different directions. None of them automatic. None of them sent to you. The beneficiary designation form, the one that controls who receives every retirement account you own. The durable financial power of attorney, the one that keeps your family out of court if something happens to you. The home sale basis records, the receipts and permits and invoices that reduce your taxable gain when you eventually sell. The beneficiary deed, the document that keeps your home out of probate and transfers it directly to the people you choose. And the property tax exemption application, the reduction your county offers every year to eligible homeowners who know to ask. The system runs on what you ask for, not on what you are owed. So, here is the list. Do these things. Contact every financial institution where you hold a retirement account and confirm your beneficiary designations on file, primary and contingent, on every account. If you do not have a current durable financial power of attorney, contact an estate planning attorney this month. Gather every receipt, permit, and invoice for capital improvements to your home. If your spouse recently lost their life, ask a CPA to calculate your current adjusted basis before you make any decisions about the property. Search whether your state offers a beneficiary deed. If it does, ask an estate planning attorney about having one drafted. Call your county assessor's office. Ask about the homestead exemption, the senior exemption, and any income-based property tax relief program. Ask if you are currently enrolled. That $47,000 the IRS collected from the widow we started with, it did not have to happen. The rules were there. The documents existed. Nobody explained them while there was still time to act. These are not loopholes. They are the rules. The IRS just does not explain them. Take care of yourselves and take care of your paperwork. Important note, I am a retired federal tax employee, not your tax advisor. Nothing in this video is personal tax, legal, financial, or investment advice. Tax rules change and your individual facts matter. Before you act on anything covered here, speak with a qualified CPA, enrolled agent, tax attorney, or estate planning attorney. For unresolved IRS problems, look into the Taxpayer Advocate Service. If you qualify based on income, also check VITA, TCE, or a low-income taxpayer clinic near you.